I just wish to conclude my submissions by making two brief points, if I may. The first is to draw to your attention the concept of over-inclusive legal rules, by which I mean this: a rule which has the virtue of being clear, which may be overextensive, but which deals with the mischief. A good example in my submission is the 2-year qualification period for unfair dismissal, the basis for which is, as I understand it, that some period is needed to assess the capability of employees before they acquire rights. In many cases, employers will be able to do that well before the 2 years. But that doesn't influence the legislation, because we want a clear rule that is obviously capable of dealing with the mischief. And in my submission, that is in part what is called for in this case. Mr. Burns' ideal world, in which everybody knows the purpose of events in various different countries, is not the real world. It may be that the solution put forward by the CAC was over-inclusive. It will lead to some unnecessary EGMs. But in my submission, that is justified by the need to ensure the effectiveness of the information and consultation provisions which are assured to employees by the directive. Going on from there, there was a number of references to earthquakes in Portugal and Bulgaria, I think.
Fire in one and an earthquake in
yes,
another.
Yes. In my submission, that is just the sort of occurrence which is rendered irrelevant by the need to have clear rules protective of employees' rights. That is the sort of occurrence which will be tolerated by the sort of rule that I've just...
So it doesn't matter if there's no linkage at all. If you've got a clear provision
Yes.
that can be interpreted
Yes.
clearly.
Ease of application is highly valuable in this area. And the final and related point I wish to make is the reference to the hardship which the CAC and EAT's rulings place on multinational corporations such as the appellant.
The burdens.
The burden,
yeah.
Yes. Burden. You made your own very forthright and, in my submission, perceptive comment on that, insofar as it referred to mechanisms to get information about what was going on. But in my submission, it applies more generally. Mr. Burns made a number of submissions about how unscrupulous EWC reps would engage in unnecessary discussion at EWC level if the EAT's decision stood. In my submission, that is pure speculation. There's no reason to think that that would happen. Rather the contrary, that EWC reps might want to get through the meetings to get back and get their work done. Either is possible, there's no evidence of either. And the submission is, in my submission, a clear example of projection of unnecessary burden, which you should disregard. Madam, I'll just take instructions to anything I've missed, and then I've finished. Madam, those are my submissions.
Well, a couple of things, if I might. First of all, over the short adjournment, we've been looking at the CAC decision itself.
Yes.
And it doesn't appear to make any findings of fact at all.
It recites, does it not, in extreme length, as Mr. Justice Kerr put it, what was said to it.
It recites both what both sides said to it.
I think that is fair. Mr. Justice Kerr was somewhat acerbic about that in debate. And that does bring me to the question of disposal.
Well, that's why I'm raising it,
yes.
just to see what you say about that.
Mr. Justice Kerr addressed this in his judgment, and his decision was that if he was wrong in upholding the CAC's reasoning, the matter should be remitted back to the CAC
for
findings of fact, application of the law as it should have been understood.
Yeah, okay.
One can't help, and this what one can never know, but one can't help but think that the CAC's view of the law led it not to address some of those factual...
Because the CAC said a link was irrelevant.
Yes, so they didn't think
about it. Yes, it just wasn't necessary, whichever way it went.
Absolutely.
So on that question, if I might just tax you with it for a moment, a couple of things. The first thing is looking at the clause in the agreement on page 11 of the supplemental bundle behind tab 1. This is the clause that we're construing.
Yes.
As I understand your submissions, but tell me if I'm wrong, whatever the provision, whatever the directive and the regulations require, it's your submission that that provides a floor of obligations and an employer and its unions can go further. And if necessary, you say this agreement does go further.
Yes.
Right. So I just want to understand what you say about the meaning of the different exceptional circumstances and decisions identified in A, B, and C. Because if we focus on A for a moment, well, let me start with the predicate. If we look at the predicate, extraordinary meetings will be convened to provide information on, and then, as I understand your argument, there is a composite phrase which defines particular transnational circumstances in this Adecco context.
Yes.
So the words following transnational issues where exceptional circumstances or decisions arise is all one thing, and they are then defined in A, B, and C.
Yes.
And those A, B, and C are standalone definitions. Is that right?
They are examples, I would put it, but
well, it's only those. So they're...
So, yes, I beg your pardon.
They're not just examples. They are the three situations where an EGM arises. And those are themselves identified as transnational issues giving rise to exceptional or involving exceptional circumstances and decisions.
Yes, madam.
Right. On that footing, if that's your submission, can you help me about A?
Yes.
Because A doesn't have the words transnational effect in it, and we can't import the words transnational effect because the predicate doesn't do that. You say these are standalone transnational situations.
Yes.
So would it apply in the event that there were relocations between Newcastle and Derby?
This is an issue that's addressed in both our written skate arguments. My learned friend says, well, A shows that there have to be some qualifications, and therefore...
I know what Mr. Burns says, but I want to know what your submission is.
My submission is this. I have to acknowledge that in the event of substantial relocations was not intended to cover the Derby and Newcastle example.
Well, where do we get that?
We get that in this way. This is a contract as well as the inculcation of the directive, and like any contract, it is subject to interpretation. And my argument would be, and I think Mr. Burns would probably agree on this, that it has a necessary implication into Lim A that the relocations must be within different countries. It doesn't make sense otherwise, as I concede. It is in the next step that I...
But so what? What are the words that we read into A on your on your analysis?
From one EEA country to another EEA country.
So that not only identifies something happening in two countries, but it identifies a linkage, because the relocation must be from one to another. So
Yes.
there's a linked decision.
Yes,
Okay.
that's right.
Okay. So what about B then?
B, where I land with B is as follows, that my concession, if you call it that on A, is one to which I'm driven by necessity. It doesn't make sense without it. But as to B, I'm not driven to a similar concession because it does make sense without it. When one looks at the factual matrix, as we have been doing for the whole of the morning.
And then C, what do you I understand by the words having transnational effect? Is that actual or potential consequences or effects in two countries? Does that include the linkage that Mr. Burns contends for?
The situation envisaged in C is the purchase of a business in country A, which has effect, or we would say by implication potential effect, because
yes, potential is there.
In another country.
So there is the linkage,
Yes.
the same linkage as you're implying into A. So the only one that doesn't have the linkage is B.
That's right, but the linkage in A is implied to avoid absurdity, and in C is inherent in the text. But neither the text nor necessity nor the purpose of the directive require it in B.
And why do you say the purpose of the directive doesn't require it in circumstances where both the scope of the directive and actually the scope of this agreement don't just look at the coincidence of something happening in two countries, but look for something that concerns a single matter that concerns or has potential, give me the actual words, concerns or has potential effects on two undertakings in two different countries. So that linkage.
The linkage, however, is not the linkage on which Mr. Burns takes his stand, the need for a decision by the parent company, effectively. It is the linkage which arises from the nature of the matters in question.
Yeah. So are you accepting that linkage is there in B, that linkage coming from page 4 of the scope provision? Are you accepting that linkage is there or not?
It is, but not in the sense that Mr. Burns says it is.
Well, leave aside what Mr. Burns is saying. I just want to understand what your argument is. Are you accepting or not that the whole predicate of the EGM is to discuss, by informing and consulting the Works Council, where there are matters concerning or having potential effects in at least two different EEA countries, giving rise to collective redundancies? Or are you saying those words are a standalone definition of what is transnational for these purposes?
I am saying that B is a standalone definition, and if and insofar as it is over-inclusive, for the very good reasons that I have put forward to you earlier in my submission this afternoon.
Thank you. I think I've got the point. Thank you very much. Thank you, Mr. Adair. Mr. Burns.
Two short matters. The first, on that last point, the reason that what Mr. Adair calls the attractive elegance of the binary solution is right, and the over-inclusive answer is wrong, is that this is a binding contractual agreement. So it's different from what in the UK we are used to in industrial relations, which are non-binding agreements in honour.
Yeah.
Both parties are able to comply with or not to some degree.
Yes.
This is absolutely binding. So
yeah.
if it's transnational, the employer, the transnational entity must disclose sufficient information in advance of the extraordinary meeting for the steering committee to take into account. If it's transnational, they must have a meeting which is either going to be in person in accordance with the Oracle case, or if it can't be transnational, if it can't be, it can be virtual. Then the multinational entity needs to pay for the EWC to have its EWC expert instructed to assist the EWC in reviewing its information and meeting, and then it needs to get the parties to a central location, including in some EWCs with interpreters, because the language of the EWC, and then it needs to give the EWC time to consider with its expert and provide an opinion. It then needs to take into account its opinion before it can then implement. And then when the director talks about burdensome and not delaying employers' decisions, that's burdensome is perhaps putting it in a pejorative way, but that's the process. The expensive, and if an employer is up against making a swift decision about a downsizing, and employees want to know where they stand,
it must comply with its contractual obligations.
Absolutely, and that's why it's no good to say, oh, well, this is over-inclusive.
Well, if the contractual obligation is more inclusive than the directive, that's what they've agreed. Well, that's what he's saying.
Absolutely, but if it's a over-inclusive answer, so we can construe this more widely than its exact terms, because then nothing falls out the sides, which I think is Mr. Adair's over-inclusive approach. Okay, it means this narrowness, but let's CAC are right to go beyond that, so that nothing falls off the side.
That wasn't my understanding. My understanding of what he's submitting is the directive and the regulations provide a floor, but it's up to the parties to reach agreement. And if the agreement, properly construed, goes beyond what the minimum floor required by the directive and the regulations reflect, so be it. And that's not so terrible, because it gives certainty and it makes their information and consultation rights properly effective. That was my understanding. But so why don't you address that argument?
If it was going further than the directive, it would have used words differently from the directive.
Well, let's look at the words, because the words are on the following transnational issues where exceptional circumstances or decisions arise, and then they're self-standing.
Actually, you got my submission, but remember, it's scope that I win on. It's clause 2. We don't get to extraordinary meetings clause.
Is that right? Because
by 1A, because the matter has to be a clause 2 scope in order to get into the agreement at all.
Well, is that right?
Can I just ask you on the scope? I mean, we'll obviously have to decide whether it's right or not. But in the scope, I didn't ask you about the potential effects wording. That doesn't seem to come from the directive,
No.
and might have been included for good reason. And just this possibility, because obviously, the wording was slightly bogged up anyway, because as the CAC had pointed out, there were bits missing and some words weren't properly transposed. But adding in potential effects, I mean, you are in a situation where if you've got two collective redundancies, I mean, these things happen. It might just be an unfortunate coincidence, but it is a potential effect of both. And then a works council can look and see whether there is anything that is to be teased out from that. And that might, the deliberate width of scope would then tie in with defining two collective redundancies as being something that you look at.
I agree, that's probably right. And in some ways, the word in the directive is concerns, which is a causation word which could be looked at as narrow or wider, but probably could be looked at as wider. And so I have to stand on that, absolutely. There needs to be some relationship, and it doesn't have to be a direct relationship. It could be an indirect linkage, to use the word, between Sweden and Germany. It could be a knock-on effect, as the
Well, COVID is a good example, and we saw from the document
a common
that
rationale.
COVID was in the mix, although the company said ultimately it wasn't the reason, but they did acknowledge the possibility.
Well, COVID was in the mix, hence having the 10th of June additional meeting to discuss COVID-related issues. Didn't need to, but it wasn't anything to do with Sweden or Germany, because those two were related to different things. It turned out that they were wrong about that.
But if my Lord's point is
on the potential effects, which is so concerns. I'm just looking at the directive. Yes, no, it is the submission I made earlier. I relied on that because it's at page 3 of the authorities bundle. I took you to that because the transnational character of something is determined by the scope of its potential effects. So the agreement is lockstep with the directive. So whatever the interpretation of this agreement is, that's the interpretation of the directive. This isn't a gold plating. This is just putting the directive absolutely into effect.
And so we'll have to assess Mr. Adair's submission that actually his construction's in accordance with it, and your submission that it's not.
I'm sorry, I cut across.
No, I think that is the answer to the point.
And I do accept, as Mr. Adair says, that there's a spectrum, but I think he mischaracterised my submission by saying that only matters at one end, at extreme end, are transnational. I don't say that. I say that the tribunal, the CAC found that Sweden and Germany were wholly unrelated.
Well, they didn't find that.
Well, they did.
Did they? I thought they said it was irrelevant.
You have to tease it out because this
Yes.
is a CAC decision. But if you look carefully, you'll see that they did, and that's in. I mean, it's a strange old format, but that CACs are always that, and they don't hear cross-examination, and they don't often hear.
Can they though?
They can do if you ask the.
Yes.
The
If you
CAC
say
chair.
I don't accept the evidence, and we will need to
Often
have
they'll do
witnesses
cross-examination
cross-examine.
through the chair, so a sort of quasi-inquisitorial approach. But they don't like people like me cross-examining.
So were you there at the tribunal,
No, I wasn't.
Mr. Adair?
I don't think it was a hearing. I think this was done on the papers.
On the papers, yeah.
So I was there in written form, not in person. So if you look at page 126. And you see, this is as far as we can find. This is the part where the tribunal make their findings and conclusions, and it does go further, I say, than they just recite. So first of all, they make a finding that they don't accept the employer's submission about common rationale, and they explain that. They consider the weight placed on the reference to singular transnational issue, which is a subsidiary submission. Second, then they come across that sentence begins, this panel is satisfied. That's the single transnational issue. So again, there's a finding, that's a conclusion. They then say another sentence, 4 lines up, the panel is satisfied that where there are collective redundancies which sufficiently affect Adecco employees in each of at least 2 countries of which Adecco's employers, they find it's irrelevant whether, to use the words of the employer, that they are separately formulated in different countries in light of different national circumstances. First on that, the only proper reading of that must be they accept that these 2, Sweden and Germany, were separately formulated in different countries in light of unrelated national circumstances. And that's why they make a finding that it's irrelevant, because otherwise the only reason for them to make a finding that's irrelevant is if it mattered.
No, it's dealing with your point on construction. I mean, just so that you can address a concern about this, what they've done is set out in very accurate summary, it seems, the careful submissions your side had made and Mr. Adair's side had made. And then they deal with it effectively as a point of law. They say it's irrelevant, whatever. They're not saying we accept that. Indeed, I mean, it's slightly frustrating.
They don't expressly say that, as you say, very frustratingly, but they must have accepted that that's the position. Otherwise, that would have given them the complete answer to the case. They wouldn't have needed to say, oh, it's irrelevant, because they would have said, well, these are linked. Therefore, only if they accepted the factual evidence do they need to find that it's irrelevant.
Isn't there another reading of it which is doing the best one can, that they're saying we don't need to make a finding about whether they're linked or not because on our reading of the legislation it doesn't matter anyway?
It would be a very, very strange way of reaching a judgment if they did.
Well, it uses the word irrelevant.
So in my submission, they must have had in mind, because if they weren't separately formulated in different countries, and if it was related national circumstances, if it was related circumstances, then that would have been the straightforward answer to the case. Mr. Dare would have been right, and I would have been wrong, and the irrelevance wouldn't have come into it. Secondly, they find that it's irrelevant that there's country-specific reasons. Again, it seems to me that the inference must be that they accepted that there were country-specific reasons, because otherwise we then see that the panel does not consider it a barrier to compliance that each country may be acting autonomously. Once again, they must have considered that each country was acting autonomously in order to need to make a finding that it's not a barrier to do so.
Why didn't they say was acting, and we find as a fact rather than may? I mean, just so that
that's a fair point.
Well, I mean, it's not your fault you didn't draft it, but if you're right, just so that you can deal fairly with this point, if you're right, what Mr. Adair has said, well, they've not actually addressed, our case that in fact there is a linkage to the extent. What do you say about his submission that if we accept your submissions on the law, it has to go back for proper findings? Perhaps with a strong encouragement for the parties to talk to each other.
Yes. Is there, the question, I suppose, would then be for this court, is there any material in front of the CAC on which a reasonable CAC could come to the conclusion that the Swedish national recession, which led to redundancies, had some impact in Germany?
Don't we have to do it the other way round? Don't we have to say, if you're right, the only possible conclusion?
I'm coming to that. I'm exactly coming to that.
Okay.
So first of all, is there any evidence at all? And to which the answer is, there is no evidence at all, because the employers, the EWC's initial case on their letter was this was COVID, and that was put by the employer saying, well, these were redundancies which preceded COVID. So you're just wrong about that. And the findings they do make at paragraph 58 seem to accept that, because they find that there's no linkage between the circumstances that existed in Hungary and the Netherlands, and they find at the end of paragraph 57 they couldn't be properly said to be an ongoing or part of any kind of continuing act with the events on or after 24th of May 2020. So what they have made a finding here, which is there was no continuing act or no circumstances which could properly be said to link the events in Hungary and the Netherlands with the events in Sweden and Germany. We know that because that is a finding.
Yes, they did make that finding.
So we've got. So we know
we need to worry about Sweden and Germany.
So the only and they must have done that on the evidence that they then set out in those paragraphs, in paragraph 56 to 58. Therefore, they must have been taking in account that the Swedish national recession led the Swedish management to decide there were 65 redundancies in 1st of January 2020. They say the employer was provided evidence, but unless they'd accepted that evidence, they couldn't have said that it wasn't part of a continuing act.
Well, they could in relation to Hungary and the Netherlands because of the dates.
But Hungary and the Netherlands could have only been connected with the events on or after 24th of May, which are Sweden and Germany, because only Sweden and Germany happened after.
Yes, but they're not necessarily making. Well, I can't see where they've made findings about these self-standing country-specific reasons.
It is, but my submission is that there's no CAC that could reasonably come to any other conclusion, having found there's no continuing act which could link Hungary, Netherlands, Sweden and Germany. On the basis of what's in front of them, there's no linkage at all.
Well, the document you took us to in opening was much more murky than you were suggesting, as my Lady Justice Whipple put
That well-known legal phrase, murkiness.
Well,
that's the letter from the
Yes.
initial letter from the. But that's not the evidence in front of the. Well, that is part of the evidence in front of.
But
yes.
if one looks at, can I just tax you with 2 lines of that?
Of course.
Just because if we're right to be in this situation, so
You
you're
are-
right on
you
the
are
law,
right, because
and we have to look at whether there's any argument.
Yes.
These are the sort of things
Yes.
that you might go back to the CAC and say, well, actually, I know it's unusual, but we would like to cross-examine because I want to put the following questions. And if you look at paragraph page 31, and Netherlands, I appreciate you say Netherlands is not one of the ones, but if you look up 5 lines up from the bottom line, it says in these days of mid-June, in paragraph 1, the
Yes.
country management continues to assess the situation, such as the potential number of colleagues or jobs that may be impacted, building on the initial analysis made by COVID-19, which rather suggests that COVID-19 might be playing a role. But certainly, it's not just completely hopeless. And if one then looks to Sweden, which is the next paragraph, and you pick it up 4 lines down, regrettably, the COVID-19 situation starting March triggered customers across all segments to stop ordering. This resulted in sales falling and due to the local situation. So there's enough there for a competent advocate to at least put to the employer that COVID did play a role.
Well, yes, but no, because that's not this Swedish collective redundancy and this German collective redundancy. If you look, that is mid-June. We continue to assess in the Netherlands. In Sweden, this resulted in the 60 colleagues starting on the 1st of July. That's a later one that comes afterwards. So effectively, these are COVID-19 is making an impact, but it's making a subsequent impact in further processes. It made no impact on the 2 processes which were before the CAC, which was the Swedish management decided about 65 redundancies because of the Swedish national recession, which started on 1st of January 2020, pre-COVID, and the German management decided that it needed to formulate proposals for redundancies because of the German Temporary Employment Act.
Thank you.
So, I mean, there's material, but it's material relating to 2 other or different or additional processes.
So what is the material that you say would lead inevitably to the conclusion that these were country-specific decisions?
So there needs to be something.
Well, what are the bits of
what I say is
evidence?
there needs to be something in the pack or in the evidence before the CAC to say that the Swedish jobs that were going because of the Swedish national recession had some
impact on Germany?
potential impact outside of Sweden.
Yeah.
And there's nothing at all. There's nothing at all about that. And the German change of the law and aviation industry had some impact on workers other than German workers. And all that there is in all of the material, and the high point is, as my lord says, that the suspicion that COVID might have been behind both these two. Well, so you're right, of course, that this CAC decision doesn't do what you'd expect a judge to do, which is to say, heard the evidence, this is what I find as a fact. That's not unusual, must be said, in CAC cases, because it's a committee, it's a Central Arbitration Committee, which tries to bring parties together, rather than a body that's purely to decide rights and wrongs, but obviously it does have to decide rights and wrongs under this.
But I'm sorry to press you on this. Is there some evidence from the decision makers that says these were separate country decisions?
Yes.
Well, I'm just asking you to give me a note,
So
a reference for my note.
It was brought together in the supplementary bundle by the statements that were before the CAC. So the principal statement was that of Veronica Quake, who starts at page 108. Just pause there. I'm sorry. That's her
There are two statements
statement in the Employment Appeals Tribunal. Just 41. Yes, it's just after the letter you were talking about.
Yeah.
The statement that was before starts at page 41, which is the explanation as page 42, paragraph 8. One country's situation did not affect another country. The redundancies were due to local reasons, was what the evidence that was before the CAC from her. There was the evidence about the separate responsibilities of each country, which is effectively the decentralisation evidence, which is the evidence of Mr. Wader at particularly page 47. There's the evidence from the Adecco Germany about the reasons for and the scope of the German redundancies, which are page 49. The German manager is Danica Ravioli, Chief HR Officer of Adecco Germany. And we also called at page 51 the Chief Executive Officer of Adeco Group Sweden to explain the reasons for the Swedish and the extent. So the only evidence before the CAC was about this. I think the EWC commented on that, but
they didn't call any witnesses.
Call witnesses to contradict that, and that's why we had a hearing on papers.
So, sorry, just while we're still on the facts, you told me, I think, in relation to paragraph 31 and the bit about the COVID situation in Sweden, I think you'd accepted that COVID might be something that would be suitable to being addressed because there might be common solutions that could be proposed. You said that the COVID didn't affect these relevant redundancies. I've got, from the very helpful chronology that both parties have put together, late May 2020, later rounds of potential redundancies announced in Sweden. But that does seem to be related or potentially related to the explanation given about COVID, if one looks at the letter. And that does seem to be part of the relevant redundancies that are or at least picked up by the CAC's decision.
So that the proposal for redundancies in Sweden, as the CAC noted,
Yeah,
the redundancies in Sweden were triggered over the course of 6 months.
yeah.
The first redundancy started in 1st of January 2020.
And lasted till...
The last ones were made on the 1st of June.
Right.
In the 12th of June, I think. So 29th of June, end of June. So they were across the full 6 months. So the Swedish national recession was in late 2019. There was a proposal in December 2019, and redundancy started in January 2020 and continued for 6 months.
But the letter doesn't say it began and end with the recession. It talks about the recession, you're quite right in the first 2 lines, and then goes on to see in January and February, the Swedish business continued to see declining demand. Regrettably, COVID-19 started triggering customers to stop ordering, but for understandable reasons, which does appear to suggest some link between COVID and that, unless you can tell me that's wrong reading.
That's only what, if you look at page 51, the Swedish national recession is said by the evidence of Malin Persson, the Chief Executive Officer of Adecco Sweden, that in late 2019 and early 2020, the Swedish management analysed the impact of the recession, decided to reduce the size of the organisation, who had lost sales for a long period. The reason for the redundancies was a shortage of work because of the national recession. Reasons for these shortages varied. The lowest common denominator was that we lost sales. Between 1st of January 2020 and the 30th of June 2020, Swedish management decided to make 65 redundancies because of the difficulties caused by national recession. Many of these involved process. So that's why I say that
just to posit, is there anything to argue about? One might reasonably ask that deponent to deal with that middle paragraph and whether COVID then had any continuing effect.
My lord, I think I have to accept yes, because it may well be that although the witness statement says that all of those 31, 2, 16, 11 and 5 were due to the pre-COVID recession, he could at least be asked about whether or not the later ones were exacerbated by COVID. I suppose the position will be informed by whether Sweden had, as we had here, a sort of a furlough type scheme in which nobody got made redundant, everybody got put on hold. But again, that would be a question that could be put to him.
Thank you. Sorry to ask so many questions about the facts, but it sort of slightly arose out of Mr. Adair's point. Yes.
But my clean point is that there is only one answer to the question. Yes, COVID was in the background by June 2020, but at the time when the obligation to have an extraordinary meeting on Mr. Adair's account would have been triggered, is there any material in front of the CAC, was there any material in front of the CAC to suggest that the Swedish national recession redundancies had any impact on any workers at all outside of Sweden? And was there any evidence at all before the CAC that the German Temporary Employment Act and other German specific factors had any? And I come back to the point, the only reason that the tribunal could have or would have said, well, it's irrelevant that they're unrelated, is if the tribunal had concluded but not said that they were unrelated. And that's unsurprising because there was no evidence before the tribunal that there was any relationship at all between them. So that it is a little unsatisfactory, but I think that's where my submission has to stand. Those are the 2 points I was going to raise in the slide, with the addition of the questions asked by Lord Justice Dingemans.
Sorry.
Thank you very much, Mr. Burns.
Pleasure.
Mr. Adair, we didn't invite you to show us any evidence, as we have invited Mr. Burns to, but was there anything you wanted to say on that point? I know there wasn't evidence, but is there material
No.
you wish to point us to?
I would simply have pointed, if I haven't already, to the CAC's approach, which is to refer to certain matters being irrelevant
Yes.
to the view of the law.
And
of course
they
I
simply didn't make findings.
I would say that my Lord Justice Dingemans has pointed out some, let's say, interesting matters, but the barrier for a substitution of judgment is, of course, very high. So if you were to say there could be no other result, you would have to be very sure on all the standard tests.
Yes, we'd have to be able to say that
No other.
effectively remission can serve no purpose because there is only one inevitable conclusion on the evidence before the
Absolutely so.
CAC.
Absolutely. Thank you.
Okay, thank you.
I think on either alternative, I would say that I'd invite you to allow the appeal on the £20,000 of EAT penalty, which flows from the CAC decision. It's purely parasitic on the first point being
Yes.
allowed, of course. I've got no separate submissions about the £20,000 penalty, but it flows from the first.
Flows from that, yes, and you don't disagree with that. Thank you very much. Thank you. Well, thank you both for the concise and focused arguments, not only to those who advanced them today, but to those who sit next to or behind them. We know how much work goes into these cases, and you have clearly done a lot of work to prepare it, and we're very grateful. We will be reserving our judgments. I'm sure that will come as no surprise to you. This does raise some difficult questions, so we will take time to consider our judgments. When you get our judgments in draft, that is for the correction of typographical errors. I know you know it, but just so everybody in the courtroom hears it, not for re-arguing the case, and also the importance, please, of the embargo and the recent cases, which I'm sure you'll be aware of, in which reminders have been given by the Master of the Rolls in particular about the importance of that embargo and not going beyond the circulation list that we've agreed. Subject to that, and unless there's anything else, thank you both very much.
Thank you.
All rise.